Well, good afternoon, everyone. Good evening and good morning, wherever in the world you are. My name is Tony Druitt. I'm the head of consultancy for the GRC practice at IT Governance, and I'm going to be talking to you for approximately 45 minutes on this latest subject of data flow mapping in the context of the new European Union's General Data Protection Regulation. So here we go. Very quick bit about myself. I've been with IT Governance for 5 years and I specialise in these areas. The IT Governance's GDPR consultancy practice is now a fast-growing and independent resource within the company, which was spun out from the GRC practice, and I was instrumental in setting all of that up. The link between information security and GDPR compliance is something that is a constant theme through all of this, and we'll be touching on that as we go through this afternoon. IT Governance is very much a one-stop shop for information security and cyber resilience generally, and now of course for General Data Protection Regulation for privacy management, and we provide a range of resources, whatever each organisation needs, from at the lowest level, books, tools, document templates and so on, through training courses, through to consultancy, helping organisations to do what they cannot necessarily deliver themselves through lack of resource, competence and so on. We address all verticals, all sectors, all sizes of organisation, because ultimately information is information, and some have a lot more of it than others, some are more complex than others, but the key issues are fundamentally the same. So we're very much a one-stop shop to help people to achieve their or to meet their compliance objectives. So the agenda for this afternoon, I'm going to be talking to you for about 45 minutes on this subject. As you know, all of your microphones are muted. If you want to ask questions, please enter them in the questions panel at the bottom of the bottom right-hand side of your screen, and I'll address those questions at the end. We'll also be sending out the slide deck to all the attendees, and we'll be doing that by way of an email tomorrow. So there's no need to ask questions about the slides and when you'll get them. When we get to the end of this 45-minute session, I'm going to be going through the questions, and any questions that we have not had time to answer, or any that come in after that, we will issue a blog on our website probably tomorrow or the next couple of days, addressing some of those questions. So we're going to talk this afternoon about the general situation with GDPR, the regulatory landscape, who it applies to, what sort of information it applies to, remedies, liabilities and penalties, very big reasons for doing this, not the only reasons, but pretty big ones. We're going to be talking about the importance of risk management and linking that, as I said earlier, to information security issues as well. And then we're going to talk about the rationale for doing data flow mapping. You might call it data flow auditing. It's very much the same thing. It's not something that is stipulated by the regulation, but it is something that is a more or less essential piece of assurance work that data controllers and indeed data processors will need to consider. We're going to talk about the practicalities of doing data flow mapping and a little bit on techniques and so on at the end. So for those of you who aren't fully aware, when it comes to European law, and you'll be thinking about the impending exit of the United Kingdom from the European Union, we currently have UK laws which are a direct reflection of European Union directives, and our own current UK Data Protection Act of 1998 is such a beast, which was based on the Directive 95/46 EC. There are other directives which all have UK and other EU state laws based upon them. There are also European regulations Some of those are already in force, and this is a new one, the General Data Protection Regulation, and of course it will apply to us because it will come into force before we leave the European Union. It's quite clear in the regulation what the application is, what the inception date is, and as you can see there, the 25th of May next year, so just over a year away now, not long to go, and it will come into force. It'll obviously come into force in all EU states at the same time, and the regulation has these 11 chapters. We're going to be talking about a little bit of detail about some of these things. Remedies, liabilities and penalties, as I said earlier, big reason to be doing this, not the only reason, but very important, and we'll focus on that a little bit. Issues of the duties of the controller and the processor, and transferring personal data to third countries. Transferring data to any organization is an important feature for data flow mapping, of course, and we'll be touching on that. So I'm not going to go through all the details of these 11 chapters. There it is. The regulation is available publicly on the internet for you to download. Now, the data protection model under the GDPR is very similar to our current arrangements under the Data Protection Act, except we now have this additional layer of the European Data Protection Board, and that's an organisation that oversees implementation of this regulation and is a basis for the supervising authorities in the individual EU states to work together and through the board and to ensure fairly uniform implementation and enforcement of the regulation across the European Union. So its job will be, as it is now, to enforce this particular piece of legislation in the United Kingdom. Elsewhere in the European Union, there will be parallel arrangements. The existing data protection authority in those states will do exactly the same thing as the Information Commissioner's Office, the ICO, in the UK. So they're enforcing the law, and in order to do that, they will have to assess reports of breaches or other issues that come to their attention. There are many obligations upon controllers to notify the supervising authority in the event of breaches and in some other cases. We're not going to talk about that today, but it's an important issue that controllers need to be aware of. So the key entities that we need to consider, the controller, that's the organisation that has the most obligations or duties, as it says here. The data subject has rights. It doesn't have any obligations under the regulation, but it does have rights, and quite a lot of them. And in order to ensure that an organisation can deliver against those rights, then data mapping is one of the things that is an essential piece of work that needs to be done in most cases. We need also to think about third parties as well as third countries. Any organisation that has access to personal data, be it a data processor or anybody else, there are considerations that need to be taken into account, various articles within the regulation that need to be considered, and compliance ensured. One of the key things that a data controller must do when choosing a processor is to make sure that it is a suitable organisation and that the appropriate security arrangements are in place. If the controller chooses a processor which is outside the European Union, in a third country, then in addition to the appropriate security controls, it also needs to have certain guarantees in place to ensure that these organisations, which aren't otherwise subject to EU law, do meet the requirements of this regulation. So binding corporate rules come into play, and again, that's something subject for another webinar, but that's something that controllers need to ensure if they're going to use processes outside the European Union. Other third parties who may have access to it, to the data, the controller needs to ensure that disclosure to these third parties is only done legally, and there are lots of aspects to identifying what is legal processing as far as that is concerned. But this is a general model which indicates the sorts of entities that might be involved in data processing. The first part of the GDPR is the general applicability. Who does it apply to and where are they? The regulation refers to a natural person, which is effectively somebody who's living. When somebody dies, in most cases, their rights no longer exist. There may be certain situations where they do exist, where there is, for example, a sole beneficiary of an estate, but other than that, it relates to people who are still alive. So they've got rights in terms of the protection of their data, not only to do with keeping it confidential, but also things like having it transferred to another organisation or having it corrected or altered if it's wrong. The type of data and scope is effectively all data about a natural person. That can be as little as just an email address, and it may well qualify as personal data. Whether or not it's processed wholly or partly by automated means refers to large-scale data processing, often involving what's known as profiling and other ways of processing data in large volumes, where there may be some additional risks to the rights and freedoms of those data subjects. But also anything that is either part of or going to be part of a filing system, which in most organisations is probably every single piece of personal information. There might be the odd minor exception where, for example, a letter that doesn't get filed doesn't count, but everything else will do. So whether the processing of the data takes place in the EU or not, it applies, and there can also be controllers outside the European Union, and we've already seen a lot of interest in this from organisations that are controllers that are effectively offering services within the European Union, and in order to offer those services, they need to process personal data. So it's widely applicable. And as I mentioned earlier, one of the big reasons for doing this is that there are remedies and penalties associated with not doing it. These are the key articles as far as this aspect goes. Data subjects have a right to this effective judicial remedy, and supervising authorities are obliged to pursue complaints made by data subjects. If a controller is not in the same member state as the subject that makes a complaint against it, then they may be required to attend court in the subject's member state. It's usually up to the data subject to initiate any action if they're making a complaint, but controllers need to be aware that they may be required to engage with courts in other member states. Compensation, both material and non-material subjects have a right to this now, and whilst this typically will be adjudicated by the supervising authority, it's a stronger right than is currently available under the Data Protection Act. And the fines, this is the probably the most important obvious penalty. There are two levels of fine, and this is the higher level. This is the maximum penalty that the supervising authority can impose for an individual breach. Yes, 20 million euro, and for organisations in the UK, they're going to be subject to the vagaries of foreign exchange as well. And for those that have got worldwide operations, it is up to 4% of the worldwide turnover in the preceding financial year. So you can imagine that an organisation that had a very good year last year and is maybe going through difficult times in the current year, and partly as a result of that, they breached the GDPR, well, next year I suppose I'm talking now, the fine nonetheless would be based on the preceding year where they may have had a good year. So, and it's based on turnover, not profit. So in theory, this penalty could be enough to close down some organisations. So those are the key things about the penalties. We've highlighted here a couple of points with regard to the lower level of maximum penalty, and those are the articles to which the lower penalty applies. 2% of worldwide turnover, or 10 million euros, still likely to be enough to close down a number of organisations. And the key precautionary measures that most organisations should think about very seriously are the red ones. An organisation that does not engage in data protection by design and default. That really means organising data processing on the basis of the maximum level of caution, rather than hoping things will be okay and retrofitting later on. And also conducting data protection impact assessments, DPIAs. The regulation requires DPIAs in a number of places, but whether or not it should be done is open to interpretation. And if one is engaging in data protection by design, then one is more likely to do a DPIA rather than not. So these are two particularly important aspects when it comes to defending the organisation against penalties, and because the supervising authority will determine what the penalty is, an organisation that hasn't engaged in those two red areas is probably likely to receive much stiffer penalties in the event of a breach. And these are the particular articles that relate to the higher level of penalty. You can read through the regulation and see where these penalties apply. But for example, if the processing is not lawful, then and that's the only thing that was wrong, then the lower level of I beg your pardon, the high level of penalty would apply. If consent isn't properly obtained, then the high level of penalty would apply. So many people think that this high level of penalty is just for special categories, sensitive personal data and so on, but it isn't. It's for obvious violation of the regulation for some of its fundamental aspects, such as the lawfulness of processing and the obtaining consent legally and properly. Now, risk management is a key theme running through the regulation. The regulation doesn't say you must do this and you mustn't do that. It also says that the controllers and indeed processors must take risk into account, and it's mentioned, as you can see, over 60 times. So that's a significant number of instances, and any organisation that doesn't adopt some sort of risk framework approach to compliance with the GDPR is surely opening themselves up to considerable liability in the event of a breach, liability to very stiff penalties. So talking about risk, I'm sure most people are fairly familiar with risk, and many have their own idea about what risk is. And there are a number of definitions available, and most of the ones coming from, shall we say, authoritative sources such as ISO or the Institute of Risk Management talk about it being some combination of impact and likelihood of the event taking place. So in the case of data protection, we might be talking about, for example, malware getting into a network which then allows unauthorized access to some personal data from outside, something like that. And we can estimate what the impact of something like that would be, and we can also estimate how likely it is for it to occur, and our estimate of how likely it is to occur would in some part be based upon the current level of control that's in place. Only one of those definitions, the Organisation for Economic Development, just talked about it as a situation involving exposure to danger. But exposure to danger doesn't mean it's definitely going to happen. It means there is a chance of it happening. So implicitly, it's pretty much the same thing. So risk really is a combination of the impact of something happening and the likelihood that it will happen. Some things are quite likely, other things are extremely unlikely to happen, and that likelihood should be taken into account when deciding upon the appropriate security measures within a compliance framework for data protection. Now, there are various standards and codes available dealing with risk management. I've already mentioned ISO. There is a generic one, as you can see, called ISO 31000. There are others, a couple of other ISO standards which are based on or include risk management principles. 27005 is part of the Information Security Standards series, specifically addressing information security risk management, and ISO 22301 for business continuity management, that includes risk as well. That's not in the context of necessarily of data protection, but it uses exactly the same principles as the other ISO standards, and those are very similar principles to the other standards and codes mentioned there. Just very briefly on ISO 31000, as I say, it is a generic risk management standard. It's applicable to any form of risk management in any domain, in any organization. The fact that it's a framework brings with it a form of consistency, which is the sort of level of control that would be expected for an organization addressing risk related to data protection. If decisions about whether or not to accept individual risks are not based on some sort of consistent acceptance criterion or a risk appetite, for example, then that's one way in which the process would be inconsistent and could easily result in the wrong risks being accepted and good risks actually not being accepted and money spent on controlling them when it needn't be spent. The PDCA, that's the Plan, Do, Check, Act model, that talks really about a reiterative process because, of course, the threat landscape changes, the vulnerability landscape changes, the organizations change, forms of data processing change as, for example, technology evolves. So the reiterative nature of a risk framework based on Plan, Do, Check, Act is almost certainly the right thing to do, whether it's based exactly on that model or any other basis of doing things on a regular basis. That's what's important. And this is adapted from the ISO model for risk management. Remembering that the GDPR mentions risk more than 60 times, this is a fairly important thing for us to get right. Establishing the context includes thinking about what sort of risks are involved. If we think about digital data nowadays, of course there can be a combination of on-premise, outsourced and cloud infrastructure for systems. As those things change, and many organizations are going through a process of changing from on-premise to outsourced and cloud infrastructure, usually on the basis of cost and availability, and in some cases going back again because they realize and discover that there are risks that they didn't think about. But that's a way in which the context might change over time. Risk assessment itself, obviously the risks themselves have to be identified. There needs to be a consistent way of identifying risks, such as the example I mentioned earlier about unauthorized access to data, unauthorized logical access. We then need to analyze the risk in a consistent way, in other words, to work out the size or the amount of risk in each case, and then to evaluate each one to determine whether or not it's acceptable. Of course, many risks have to be accepted in organizations and businesses, otherwise they cannot operate. We cannot operate without risk, and the evaluation process is really comparing each risk with a risk appetite or risk acceptance level to determine whether that risk is acceptable. And in the case of data protection, it's important to make sure that the risk appetite reflects the GDPR, the penalties for breach, and also the desire of each organization to do what is right to meet the terms of that regulation and to honor the rights of data subjects. So risks that aren't acceptable need to have something done about them. We refer to that as risk treatment. Very often that's going to be by improving security controls related to an individual system or application or network. Or in some cases it could be delivered by something like a policy. And when the level of treatment is deemed acceptable for each risk, then the situation simply needs to be monitored and reviewed until the next iteration. And what's important is that the regularity or the frequency of reiteration should be appropriate, because if an organization is changing very rapidly, it could be growing, it could be changing its business model, then the rate of reiteration or the frequency of reiteration of the risk assessment process should probably be higher. It should be more frequent. And throughout this process, it's likely to be important to communicate and consult with certain parties. For example, there are certain provisions, certain articles within the regulation that require the controller to inform the data, I beg your pardon, the ICO, the regulatory authority, supervising authority, if a particular form of processing represents high risks. So that's a form of communication and consultation that would be appropriate in this case. Data protection risk assessment almost certainly should be part of an enterprise risk management program because the organization should ideally be applying a consistent approach to risk management across all of its risks. Remembering, as I said earlier, that the risk appetite associated with data protection may need to be modified because of the importance of data protection and the penalties that could arise from failing to comply with it. But the organization can make productivity and effectiveness gains if it has an enterprise-wide approach to risk management rather than doing individual separate risk management activities for different aspects of the organization. There are certain gains that can be made in terms of identifying opportunities. Risk management programs can do that, and improving the way that money is spent on risk controls. It would be foolish, for example, to spend a huge sum of money on something like a physical security risk, where that risk is lower, and particularly the impact associated with it is significantly lower than something like a data protection risk. And if the budget is all spent on one form of risk and nothing is left for others, then that isn't what an organisation effectively wants to do. So seeing a data protection risk as part of an enterprise-wide program is likely to be the most effective thing that most organisations can do. So if we think about the types of risk that organisations need to consider, these are probably the 5 main areas. Many people in organisations, particularly smaller ones, will be focusing on their business performance, their financial performance, and quite possibly managing their reputation, and also being able to do their job, the operational capacity, the risks associated with not being able to deliver what they do. Those are likely to be in the forefront of most managers' thought processes. And very often the other forms of risk that we need to think about on the right there, compliance with laws. There are a huge number of laws and legal instruments and articles that apply to most organisations and businesses, and there are risks associated with breaching those. Often breaches can take place unintentionally, accidentally, and unknowingly. So there are risks that need to be identified, and employment, health and safety, and general company law but 3 other forms of legal risk that organisations carry. There are others too. Some organisations, of course, are regulated. Regulation is effectively a form of licensing. So, for example, firms that are regulated by the Financial Conduct Authority in the UK are, if they comply with the requirements, are effectively licensed to do what they do, licensed to operate. It's not mandatory. They can stop complying, but it means that they're no longer allowed to offer that particular type of service or do that particular type of activity. So that's the difference between regulatory in the UK sense of regulation and statutory, meaning legal requirement applicable to all organisations. It's unlikely that there would be specific requirements in contracts to do with data protection and privacy, because most organisations will rely upon the law to deliver what they need, but it's possible. However, when it comes to information security, it's more common that there are specific requirements in contracts relating to particularly information security controls, and those will need to be taken into account when looking at the information security arrangements that need to be put in place to ensure compliance with the General Data Protection Regulation. So talking about information security, the first 2 points there are taken from the GDPR itself. And in the first one comes from the first 2 or 3 clauses. It's focusing upon security and confidentiality. Now, we're going to go on to say that confidentiality is one of the 3 key attributes of security. The wording doesn't really matter, but the regulation goes on, as I've said there, I think 36 times, I think I counted that correctly, to mention appropriate safeguards, and those safeguards are to do with information security. Safeguards to ensure that the data is protected, particularly in terms of its confidentiality, but also in terms of its integrity, its correctness, and its availability. So going a little bit further down the slide there, information security is very much about how the confidentiality, integrity and availability of information is preserved. Not only the information, but the tools that are used to store and manage and process that information, the assets, hardware, software, even physical assets that in some way act as a container for information systems like buildings and rooms and physical security devices. Those are all assets that support and enable the use and protection of information. And that's what information security is about. And importantly, it is not just about confidentiality, though that is the attribute that most people automatically think of. It's also about the integrity, the correctness of it, and whether or not it's available. Now, the rights of subjects in respect of availability do exist. There may not be as many of them as there are for confidentiality, but do exist. And so organizations have got to be able to have the correct information available whilst keeping it confidential. Already mentioned the type of assets that could be involved, the information itself, of course, but the ICT, the systems, the logical and physical infrastructure that enables that information to be held and used. The forms of protection and preservation typically controls, not only logical controls, network and device level controls for IT systems, but also, as I mentioned earlier, physical controls and human controls as well. If we're going to entrust people with access to personal information, then we probably need some way of making sure that that trust is valid. So there are a number of human control arrangements, usually in the form of policies, but also procedures for ensuring that the risks are minimized. The supply chain may be relevant as well, and in this context, we're mainly probably talking about data processors, but as I mentioned earlier, there could be some other third parties who have access to personal information. We're going to just touch briefly on data protection impact assessment. This term is mentioned in a lot of places throughout the regulation, and as you can see on this slide, there are a number of situations where it must be performed. However, the applicability of those situations is really open to interpretation. The regulation doesn't define what is meant by new technologies. The second one is very much open to interpretation. Who decides whether the nature, scope and context of a data processing project demand a DPIA? And high risk isn't defined either. Now, rights and freedoms or rights and obligations are defined, but whether the risk is high or not, that's a matter of interpretation. So this openness to interpretation of the regulation in most organizations is bound to lead to erring on the side of caution, and it links back to the point I made earlier about privacy by design and default. If you assume that things are going to go wrong and you're going to do privacy by default, then that largely addresses the point I'm making here, which is that if there's any doubt as to whether the DPIA should be performed, then it probably should be. It can apply to an individual risk or an individual instance of processing or an individual system or project, but it can also be used to do these things in groups or sets. It depends upon the individual circumstances, and I think it's an attempt there to ensure that the regulation is not overburdensome, that the amount of work to be done to assess risks and to address them appropriately is manageable, particularly for new projects and organizations. So DPIA is an important process, and it's likely for many organizations that it will need to be done. And where it is required, these are the things that must be included, and it's probably worth focusing on the word minimum there, because a good DPIA could indeed include other aspects, but the regulation does set out what's needed. Particularly roughly halfway down, you'll notice safeguards and security measures to demonstrate compliance. Those need to be featured in the DPIA. They need to be available as evidence. So the DPIA process needs to include records, so that the fact that the assessment was done and how it was done can be traced later on. So there's a lot of requirements for a DPIA. And what it does, if done properly, if designed properly and executed properly, is it provides accountability in respect of the 6 data privacy principles that you see there. Those principles are set out in the regulation, and the DPIA helps to provide the accountability in respect of all of these. So those are the things that we're looking to establish in a DPIA, whether the processing is lawful, whether the purposes for collection are legitimate, and so on. So on to data mapping, which is the primary topic of this webinar today. This piece of information here is the, as you can see, is the Information Commissioner's Office's approach to doing DPIA. And we've highlighted the second point there, which is determining the information flows. And this links really the importance of information flow to conducting DPIA. So we know that DPIA is mandatory, is obligatory in certain situations, and because of the openness to interpretation, well-run organisations are likely to need to do DPIAs in a number of cases. And the good practice approach, as set out here, is to include a determination of information flows. If you think about it, it's common sense. You can't really do an impact assessment properly unless you know where all the information is, where it's going, where it's held, and so on. You need to know all the stages that the information goes through. So that's part of the context and setting the scene for doing data mapping. So what do we need to do? What are the challenges in doing it? Well, first of all, we've got to identify the data. With the variety of types of infrastructure these days, on-premise, outsourced, cloud, and so on, just knowing what personal data is held can be a challenge, particularly for larger organizations. If an individual within a large organization decides to use a cloud service for a particular project, for example, the organization centrally may not even know about the existence of that system, but the organization is the controller for the purposes of that data. So it can be a challenge finding all the places where users and departments and functions have set up systems and stores for data. They've all got to be identified because they're all subject to the regulation. Then we come on to the controls that are in place to ensure appropriate protection in terms of confidentiality, but also integrity and availability. What controls are in place for the data that's there currently, and where there are not appropriate controls in place, then part of the data mapping process is to try to identify what the gaps are and what else is needed, what should be implemented. Then we come on to the legal and regulatory obligations, very much the subject of this webinar anyway, but when identifying data flows, there are going to be certain aspects of data processing to which specific articles of the regulation applies. So having the knowledge of the regulation when doing the data mapping exercise is going to be hugely valuable. Otherwise, certain aspects of a particular form of processing, a particular flow, could be missed if one of the specific articles to which that applies isn't known about by whoever's doing that. So there's a competence challenge as well for an organisation conducting a data mapping exercise. But if we get it right, then we inspire trust and confidence. Trust in third parties, in data subjects, in organizations with which we deal. They can trust us to not only to remain within the law, but also to preserve the privacy of them or their clients or their customers or whoever the subjects are. And it inspires confidence inside the organization, and particularly for the governing body of the of the controller, the board, or whatever the supervisory authority is within it. It needs to have confidence that it is working within the law. Until now, too many organisations have just assumed that they are compliant with the current Data Protection Act, but they don't really know because they haven't done any form of data mapping or DPIA or any other kind of assessment to know whether they are. They simply haven't been they simply haven't noticed that a breach has happened, or if they have, they haven't been caught out. So information flow, what is it? Well, it's fairly self-explanatory. Any information that moves from one place to another, and that can mean anything from one system to another, or from one organization to another, or from one state to another, and including outside of the European Union. Any transaction whereby the information moves from one place to another counts as an information flow, not least because there are often risks associated with interfaces between systems, interfaces between organizations, states and countries. But the state of the information could potentially change when it moves from one system to another. For example, it could information could change from being personal information to being sensitive personal information. Not to know that would be a significant risk to an organization. Not to know about the change of state of information means that then there would then be an unknown risk, and if a breach occurred and the risk hadn't been identified, the outcome is likely to be more punitive for the organization, for the controller. Cloud providers, it depends on the type of cloud service that organizations use. With smaller organizations that are buying into what is known as click-wrap contracts, where you take or leave the cloud service being offered, it's often impossible to know where the data is, and doing any kind of data mapping or data flow auditing exercise it simply isn't possible. And some organizations already have started moving away from these seemingly cheap, quick and effective services because they do not know what's happening to personal data. Larger organizations may have specific cloud arrangements where they know where the data centers are, for example, and that can be guaranteed by way of a contract. So that perhaps makes the job easier. But to identify information flows, it really is a case of identifying the information, where it starts, how it first gets into the organization, what the data collection method is, and then to simply walk through its life cycle, identifying what happens to it, where it goes, who's responsible for it, what controls and safeguards are in place at each stage. And usually doing this with a number of people is a good idea, because one person on their own may not think of everything about the flow of information. So consulting people who use the information, who are involved with the information, is really essential to identify all the aspects of data flows which one person on their own might not necessarily bring up. And also thinking about what could happen in the future. This is not necessarily future-proofing, but when information is being processed and flows through an organization's infrastructure, there could well be people who know about impending changes, or either on the basis of technology or business transformation that may be happening, and their input is going to be important, because a data flow map isn't something that's going to be done every day or every week or every month. It might be done perhaps once a year or less often, and so knowing about future changes is going to be hugely valuable. So what sort of data needs to be identified? This is an example of some of the aspects of data that need to be identified, some of the areas to look, and even in terms of data items, the structure of data can be different. Many organizations hold personal data about their own employees and about other data subjects, and the structure of the data can be different in both cases. If the systems are configured differently, then the data elements may well be different. Forms of data such as biometrics or even photographic images, that's all part of personal data and needs to be taken into account. we need to look everywhere in all formats, and the regulation applies to hard copy printed information as well as to digital information, so we need to think about that. And different forms of storage, be it data inside a database or something that's on temporary storage like a USB stick. If it's under the organization's or the controller's custody, then it needs to be taken into account. In data flow mapping, we also need to think about how data moves around, how it transfers, because transfers can represent risks. In some cases, data is exported onto, for example, removable memory, and maybe physically given to another organization. Or it may be transferred through a network or the public internet infrastructure. All of those things bring risks with them of different sorts, and knowing what the flows are is important when doing the overall assessment of risk. As I said earlier, we need to look everywhere, so on-premise, cloud infrastructure, organizations that have access to the information, be they processors or others that are given access. We need to think about and identify who they are and think about how they access the information, how they use the information, what happens to the information, how well it's protected when it is accessed by third parties, for example. So this isn't an exhaustive list, but it is a good example of the sorts of types of information or aspects of a data flow map that we need to carry out. Another way of looking at it is what sort of questions would we be asking of users or custodians of information. It's important to, one of the things we can do, or should be doing I should say, during a data flow mapping exercise is to identify how the data was acquired in the first place in order to establish the legality or the lawfulness of its collection, because one of the principles is that the data must be processed lawfully, one of the principles of the regulation. And so at each stage, from collection through to any form of processing, even through to the deletion or destruction of data at the end, aspects of lawfulness need to be considered. So where the information is, who's accountable for it, who has access to it, who's responsible for its maintenance, its protection, and its lawful processing, details of third-party access or sharing, disclosure to third parties, be it digitally or in perhaps printed or hard copy form. Those things need to be identified as well. And one of the key areas of risk, interface with other organizations or systems. That's something that should always be part of the data flow map. So there's a number of techniques for doing this. These aren't particularly revolutionary or highly innovative things. They're the sorts of things that go on in businesses already. Reviewing current processes, be they documented or otherwise. Facilitation workshops are an excellent idea because, as I mentioned earlier, not one person usually can't think of everything, and when others involved in the same discussion mention a particular aspect of data processing and data flow, that might make others think that, oh yes, I do that as well. So there can also be differences of opinion about how data is processed and how it flows. And a workshop is a useful format to identify what actually goes on, particularly where these differences arise. Often that can lead to the truth, which otherwise might have been covered up. In some more complex, larger organizations, maybe questionnaires are more appropriate, because to get a lot of information from a lot of people in a fairly short time scale, the questionnaire might be the more effective vehicle. It's not mutually exclusive. That could be one of the ways of collecting the information about data flow. Observation, simply going and looking at how business processes work, that can happen as well. Relatively labor intensive and not necessarily fast enough in its own right. And then the format of the data flow, what's it going to look like? There is no definitive or standard way of doing this. It's for each organization to come up with its own way of doing it. There are various tools available to do this, but starting off with some kind of mind map or free-form diagram, tree structure, anything about data flows, that can be the starting point. Even putting post-it notes on a wall on a whiteboard as the beginnings of working out what the overall data flow map at a very high level looks like, and then filling in the detail as we go along. And here's an example of a highly advanced tool, as you can see, for mapping data flows. This is just a very small extract of something. It's the sort of thing that a workshop or a discussion or a meeting would result in. Obviously, when doing things manually, it's difficult to scale it so that you don't end up writing off the end of the whiteboard. And increasingly, there are more digital tools available to facilitate this process so that everything is scalable within a sensible view. But the sorts of things we need to identify, as you can see on the bottom left there, what the data items are, and the formats they're in, how they move around, what the methods are, where they end up, various controls that are applied, whether the data is encrypted, for example, where it's encrypted, where it's de-encrypted, who has access to it, everything that one can think of that represents some sort of risk to the data itself should be identified. And a slightly more advanced view might be something like this. This is just a layer of a digital data flow map, just showing effectively the repositories or the systems where the data might exist. That's just one layer. Another layer would include how the data was collected, or what the nature of the processing is, and who has access to it, and things like that. So that will be another layer. And obviously a data flow map can be quite a complex beast if you're looking at a whole organization, a whole controller, or indeed a whole processor. But having one of these is part of data protection by design. But by having an overall picture of what all the data flows are, the controller and the processor can then start to implement data protection by way of controls, be they policies, procedures, physical, logical controls, and so on. And the most effective way to do that is to look at the whole thing to begin with, and then work out where the greatest risks are and start there. So, as I mentioned, IT governance is a one-stop shop for governance, risk and compliance, and we are also for GDPR compliance. We offer a range of resources, from training courses through to books and tools, documentation, templates and so on, and consultancy to help organizations who haven't necessarily got either the resource or the capability to do it themselves. So that comes to the end of the slides. I'm now going to look at the questions that have been raised during the webinar. Questions. Okay. Let me just, there we are. Okay, right. Quite a lot of questions have come in. Some of them are comments, and I'll address the comments separately, where there are observations on what I've said or what the content of the slide is. The first question I'm going to address is, what steps would an organization need to take when a processor based in the US is handling EU data? Well, they're effectively the same as the steps a processor inside the EU would need to take. But if it's a processor rather than a controller, the onus is on the controller to ensure that the processor is competent, is fit for purpose, and has the appropriate controls and arrangements in place. That doesn't mean that processors can simply not bother to do anything and then blame the controller when something goes wrong. They're still subject to the provisions of the regulation, but fundamentally it's the same as for any processor or indeed controller inside the EU. It doesn't make any difference. The next question is to do with the data retention and management concerned with audio data. This is interesting because obviously audio data, it depends what's in the audio. You could also say the same thing for video and photographic information. You cannot predict whether data is going to be subject to the provisions of the regulation or not, because it depends on whether there is anything personally identifiable within it. However, that comes down to really privacy by design. If you've got a process which is collecting audio data, you've got to think about the design of the process and whether there is any chance that any particular piece of audio data will contain personally identifiable information. And if it will, then you've really got to treat that particular process as though all of the data, so that it's all subject to the arrangements that are put in place to ensure compliance. And as I say, that same situation can apply to video or photographic data. Things like biometric are included under the regulation, but biometric always relates to a person, whereas photographs and video and audio don't necessarily. So again, it's data protection by default and design. I think the default bit actually is probably the most important there. What constitutes large volumes when processing? That's a very good question, and there is no specification as to what is a large volume. Again, it's data protection by default, I think, applies there. The organizations that are collecting a lot of data from data subjects outside their own organization, so effectively dealing with members of the public, probably by and large have got to see that as large volume. But for example, retailers, a retailer who's got, a small retailer who's got a list of 100 customers, you could probably argue that that isn't large volume, but a major retailer that's got thousands or hundreds of thousands, that's almost certainly going to be treated as large volume. As I say, there's no definition of it, so it's for each organisation to think about I suppose whether it's a large volume in comparison with the universe of the sector, like retailing or public services or whatever it might be. But as with all of the questions of applicability, it's going to be necessary for many organisations to seek legal advice. Now, we're not a law firm, we're not lawyers, and we're not giving legal advice. We can give a lot of advice on the implementation of arrangements to ensure compliance with GDPR, but matters of interpretation of the law, where they're necessary, are definitely going to be an issue for a qualified lawyer. Why are rights taken away upon death? As far as I understand it, it's a fairly sort of, if you like, binary situation. The rights are given to natural persons, and that means anybody who's still alive. Why the lawmakers didn't extend the rights to people after they're dead, I'm afraid I can't answer that question. That's very much a fundamental principle of the regulation, and not something that we can particularly address here, except to say that an organisation that is processing data and routinely the subjects die. So, for example, a company that's handling the administration of pensions, they might have more occasion to, or they might have more data subjects who are no longer living. If I was involved in that organisation, I would apply the principle of data protection by default. Just because somebody is dead, why would you deliberately compromise their personal data? And I think one of the principles behind this probably is that if you apply the principle to people who are dead, then in theory that it could apply to every person who's ever lived in the history of the earth, and that would be much too onerous for any organisation to deal with appropriately. So that might be one of the things that's behind it. Addresses are classed as personal data. Does that include business email address? Effectively, it's anything with which a natural person can be identified. So the answer is it can be. It depends. If you've got an email address which is something like, I don't know, fyx1234@gmail.com, I would suggest it's impossible to identify a natural person through such an email address. But if it's tdruitt@itgovernance.co.uk, that certainly counts as personally identifiable data. And so companies and organizations dealing with business customers and suppliers, the individuals within those organizations, the information that's held about them is by and large or generally going to be counted as personally identifiable information and therefore subject to the regulation. The next question, okay. Right, will the fines apply in the UK since the EU won't be able to levy them? I presume that question means after we leave the European Union, perhaps it doesn't. Yeah, what will happen is that the Information Commissioner's Office in the UK would be responsible for imposing the fine. And I think this is where the supervisory authorities in the different EU states would work together, where a breach is a trans-border breach or a cross-border breach. Yes, the ICO cannot levy a fine on somebody living in Germany, for example, so it would need to work with the supervisory authority there. There is the concept of, and I forget the legal term, but there is the concept where laws in one country can be enforced in another state. So it could be that in our case, the ICO can impose a fine on, for example, a citizen of Germany through that particular route as well. So I think there's probably the two options available for the imposition of penalties. After we leave the European Union, as I mentioned earlier, this regulation will become part of the UK statute book. It can subsequently be changed or repealed, but until such time as it is, then the fines would continue to apply. For organisations in the UK that are acting as a data controller or a processor in respect of the remaining EU subjects, then the law will still apply, just as it does now to controllers and processors, for example, in the USA. Okay, the next question. There's quite a complicated one about HSCN, that's the NHS's network. I'll deal with that one later if I may, because that's quite a complex question. Can I explain what is global turnover? It's turnover. It's not profit, it's not margin, it's turnover. So sales revenue. All sales revenue, regardless of where in the world it was earned, that is attributable to the organisation, that is what is covered. So it's a definite matter of caution for organisations with low margins, because they can have very high turnover and very small profits. And if the fine is going to be based on the percentage of turnover, it could be enough to wipe them out. But as I say, it's turnover, it's sales revenue, nothing to do with margin or profit or anything like that. The next question is about, I can see there's a lot of questions here and I haven't got time to answer all of them, nowhere near. So there's going to be a blog coming out after this answering the rest of the questions. Let me come to one I can answer here. That's a very, very long question. Okay. Will the slides be available? I've answered that. Okay. Right. What's the average time frame to implement GDPR? Well, I think obviously what we mean there is what's the time frame to implement the necessary arrangements to ensure compliance with GDPR. Well, that depends very much on the size and complexity of the organisation. For large organisations, it could easily take 18 months. So for some, it's already too late. But for very small organisations, it could be done literally in a matter of a couple of months. It really does depend on the size and nature and complexity of the organisation. So there's no single answer to that. Okay. Right. Information flow, does it include flow within the organisation from one department to another? Yes, it does. It doesn't have to. Remember that the regulation itself does not specify data flow mapping or data flow auditing. It does refer to flow, but for the most part, it's talking about flow in the context of from one organisation to another. However, to manage risk appropriately, it makes sense for an organisation to not only map data flows between it and other organisations, but also within its own organisation, for example, from system to system. Now, that can be an onerous job, and it's for each controller or processor to determine what level of detail it can go down to. Yeah. Would you link the information flow to any information sharing protocols that are in place? Very much so, because one of the things we should be looking to do in data flow mapping is where information is being shared, where it's flowing from one organisation to another. If there is a protocol or an agreement or any other form of control in place, then we need to understand what that is and ultimately determine whether it's adequate, an adequate risk control. So yes, very much so. That's a very long question. Okay. Okay, well, ladies and gentlemen, we've now just gone past the hour, so I'm going to call it to a halt. There's a huge number of questions, and I'm sorry that I couldn't answer more than a small percentage of them, but all of these questions will be put into a blog, and we'll answer all of them, those will be made available to you after the as soon as we can in the next couple of days. As I said, the slides will be sent out by email tomorrow. Thank you all for your interest and attention. Thank you for your questions, and we look forward to speaking to you again on future webinars in this series. Thank you very much, and good afternoon.